Hi, my name is Eric Chen, and I'm a licensed attorney in Maryland and founder of Zen Legal Planning LLC. Last time I talked about reasons why people pass away without a will. This time I will talk a little bit about benefits of having a will and some of the terms associated with it. When we talk about estate planning, the first thing that comes to people's minds is usually will. In TV shows and dramas, it's always about people trying to get a piece of the inheritance by trying to please the testator or a person making the will. Testator is used for male individual making the will, while testatrix is used for female individual. For simplicity, I'll just use the term testator. So what's a will? A will is a written, it could be typed or handwritten document that controls the disposition of a decedent's probate assets. A will, if prepared with legal and statutory requirements, speaks at the testator's death. During the testator's lifetime, his or her will transfers nothing. While the testator is alive, the named beneficiaries have nothing more than an expectancy, which cannot serve as collateral, since they don't have the actual ownership interest in those properties. Next, we'll talk about probate. Probate is core process to figure out how to distribute decedent's property, such as paying taxes and paying creditors and distributing to intended beneficiaries. Probate properties include real and personal property title only in that person's name. If the decedent owns property as tenants in common with another person, the decedent's share of such property is probate property. Example would be a few friends get together to buy rental property and each holds equally divided interest in the property. When one of the friends passes away, that friend's share goes through probate to be distributed to intended beneficiaries. Properties held as joint tenants with the right of survivorship is generally not controlled by will. Example would be husband and wife purchase a primary residence together. When husband passes away, the house goes to the wife outright without going through probate. But cars and other personal properties titled only in husband's name will still have to go through probate, and wife may not drive or access that car until probate case is closed. Other types of property not subject to probate are life insurance, retirement accounts, and other properties owned by a trust. Those are generally not controlled by testator's will. A will can be changed or revoked during a testator's lifetime as long as the person has the testamentary capacity to do it. And what I mean by that is generally the person has to understand what he or she is doing, understand the effect it will have, and understand general nature and extent of property being transferred or owned. All those conditions have to be present at the time of making the will. The will can be filed with Register of Wills of that county where the testator resides. Upon opening the decedent's estate, a personal representative is appointed. If the person dies without a will, a special administrator is appointed. Depending on jurisdiction, probate process could easily take months, if not years, to complete, since all creditors have to be notified and debts have to be settled. And then, depending on whether there is a valid will or not, if no will, the entire process could be even longer due to potential dispute or conflict in the family regarding distribution of the assets. Despite the fact that probate process is required regardless whether a person has a will or not, there are several advantages to a will. First, it allows distribution of testator's probate assets in accordance with his or her wishes compared to being determined by state statute. For example, if you have a really good friend that you want to leave something with, the state statute will not allow such distribution without a valid will. Another example would be a woman gets engaged and became pregnant when the fiance dies. Since they are not married, the woman gets nothing. Second, provide for appointment of a guardian for minor children. Without a will, it requires someone to petition the court to serve as the guardian for any minor children. And that still doesn't really solve the problem because as the minor children may still be placed in temporary custody of Child Protective Service before legal guardian is appointed. But we'll go into more details when we discuss child protection plan and temporary guardianships. Third, will can specify that property be managed in a trust for beneficiaries with prolonged distribution. Without a will, property is paid outright, free of trust. Example would be a high school kid who just turned 18, getting all the money that's left behind by the parents. Fourth, a personal representative can be designated and can serve without bond, giving discretion as to the distribution of property and save administrative cost. Bond is like an insurance that protects assets from abuse of trustee, personal representative, or legal guardians, and it could be expensive and hard to obtain if the person doesn't have good credit. Therefore, it's important to name someone you really trust as personal representative to handle your affairs. By doing so, you can waive bond requirement for someone you nominate. Without a will, court will appoint special administrator and it could result in conflicts among those who are entitled to serve. Example would be several family members are qualified to serve and they all want to serve. And this could really cause family conflict. Last one. A will can help determine who pays estate taxes and administrative expenses. For example, you can pass your car to your sister after balance on the car loan is paid off with money in your bank, or you can specify passing your car as is and your sister is required to resume payment of the car. So these are some of the basic information and benefits associated with wills. Next time I will talk briefly about what happens to assets when someone passes away without a will in Maryland based on current law. Please let me know if there is a specific topic you're interested in before I go into different parts of a complete estate plan, which could also include power of attorney, healthcare directives, and more importantly, trust. Thank you for watching this video.